Good morning readers. I, Harish Budhu, warmly welcome you to my channel. Learn as much as possible from my handwritten articles.
This October 21, 2020 opinion paper. The Indian legal system, public interest litigation, provides redress to disadvantaged people, poverty, helplessness, or social or economic disadvantages, who are unable to approach a court for relief. Any letter, petition, or verbal complaint or press report is treated seriously. Today's opinion paper will be along the same lines as those of yesterday and many others. The cautionary notes need not be repeated. The main focus will be once more on our judicial system. Welcome. Now let me share some of my concerns, feelings of apprehension and beliefs with you all. For some time now, I am feeling a slight pain in my right thumb. Writing is not that easy. The root cause could well be the injury caused in the 1960s whilst I was cutting sugar canes. Anyway, the pain seems to be getting worse. But then, why should I confide in you about these personal problems? That is because I fear a worst-case scenario, when handwriting will become a problem. My doctors have advised two solutions. First, give the thumb and right hand a few days complete rest. Second, utilize markers pens, instead of ordinary pens, though they are quite expensive. Anyway, let us wait before deciding. I hope the BOM and yoga exercises will produce some good results. But come what may, I do not like typewritten articles of mine, I love the handwritten particularly. All said, I am immensely relieved to have confided in you. Confidence has increased. Students column, we had highlighted 27 English expressions yesterday. The Indian legal system, what is Public Interest Litigation Act, since the 1980s. The other day, a senior lawyer referred to public interest litigation on a private radio. We have written a lot on that revolutionary and down-to-earth legal system. You may go through them. However, experience has taught us that many will not. Hence, we will just quote a few paragraphs from the two books written by Sangeeta Ahuja. The title is People, Law, and Justice. Casebook on Public Interest Litigation. And we sincerely hope that both the author and the publisher will forgive us for quoting extensively. It is all but in public interest. Just en passant, it is Pradeep Jiha who had lent me the two books. They are not available in our bookshops. I had spoken to the Indian High Commission twice. But they have done nothing. Maybe the new High Commissioner can donate the books to the Supreme Court, the Bar Council, the Law Society, the libraries, etc. They are indeed as important as metro, hospitals, Supreme Court building, etc. Publisher's notes. 1. This path-breaking study documents all the reported and unreported cases of public interest litigation from its inception in 1979 up until April 1994. 2. Public interest litigation was introduced in India to provide redress where a legal wrong or injury was caused to a person or to a determinate class of persons. Public interest litigation would apply where such persons were, for reasons of poverty, helplessness, or social or economic disadvantages, unable to approach the court for relief. 3. Unlike other countries, in India, this legal phenomenon has been thought of more as social action litigation, a means whereby the needs of disempowered victims could be addressed. Preface by Professor S. P. Sath. 1. Public interest litigation has been one of the most important innovations in the Indian judicial process of the last 2 decades. It emerged in response to a need to make judicial process more accessible to the disadvantaged sections of society, and to ensure adequate judicial protection of their human rights. 2. Public interest litigation is essentially an integral part of the poverty jurisprudence of the Supreme Court of India, which has taken shape since the late 70s. It became articulate during the post-emergency period. 3. The emergency laid bare the lawlessness of the state as well as judicial helplessness. The post-emergency court had to make a great effort to re-establish its institutional credibility as a bulwark against state repression and as the protector of people's rights. 4. if the courts were accessible only to the rich, how could they inspire confidence among the large number of half-starved, naked and illiterate people of India? In public interest litigation, the courts combine the function of an ombudsman and a human rights court. 5. Public interest litigation in the late 1970s was first envisaged by its proponents as a way of ensuring that justice was made available to those without the knowledge or resources to approach the courts, and as a forum or the resolution of issues of public importance. We stop here today. We will continue tomorrow.
Keep reading, keep learning. Like and subscribe for more thrilling articles. Thank you for watching.